to have. Good evening, ladies and gentlemen, and today we have a very distinguished panel with us. We're talking the subject of legal reforms, and none better than these three scintillating lights of the legal world to tell us about the reforms that are so badly required in the Indian legal system. First, of course, on the stage with me is Mr. Raian Karanjawala. I think there is nobody who is in corporate litigation and hasn't heard of Raian Karanjawala Co. Taking up the biggest commercial matters. In fact, any high-profile matter, whether it is commercial matters, whether it is, well, the latest Tandav case, or defamation cases, you talk about it, and his legal firm actually looks at all of these cases. Next to him is Mr. Aryama Sundaram, a man we've all known and seen so often on so many television debates, senior counsel, constitutional expert, the man who's seen the corridors of Supreme Court for so long now that he possibly knows what every brick is telling him. Mr. Aryama Sundaram, legal reforms are an important area which we would like you to dwell upon. And to my left is Senior Counsel Sidharth Luthra, a man who's made his mark in criminal, in commercial, in all kinds of matters where he's looked after the most high profile of cases, and he's somebody who's well known, right, I think, from his stint as a young lawyer in Patiala House Courts up to the Supreme Court. He's a name to reckon with, a journey that he's done with aplomb, and a name that is so well recognized. Sidharth Luthra, thank you very much for joining here. The format, the way we've prepared the format of this particular talk is I'll open the floor to all these gentlemen for first 5 minutes, which will be on a clock, for them to tell us about what their big thought about legal reforms is. And then, as usual, in the Times Now style, we'll open it up, and who knows how heated this debate will get. First, let me begin with C. Aryama Sundaram. And Mr. Sundaram, we're talking about a time when there are 3.8 million cases pending in various courts, and nearly 70% of these are in subordinate courts of the country. Clearly, the fact that there are legal reforms that are required cannot be emphasized much more than just through these numbers. How do you see the legal reforms actually taking place? Because we haven't seen over the last decade or so as far as legal reforms are concerned, including the way judges are appointed in various courts.
Navika, you've got to understand that legal reforms really covers two sides. One is the laws and the changes in the laws themselves to keep pace with the times. And the other is the dispensation of those laws, the justice. I think it all becomes very simple if we understand what are laws. Laws are nothing but rules that regulate how human beings interact with each other in a society. Therefore, those laws must always be alive to the needs of a society, to the changing moods of a society. And laws can never remain stagnant, but have to always change. Now, if you take the progress of reforms in India, let's look at the progress we have made over the last 70 years. The economic reforms which have made. The moment we have economic reforms like we have, the moment we have globalization, commercialization, all this the way we have, laws have to come into play in order to regulate these. So you have changes in the Arbitration Act. You have changes in competition laws. You have changes in various laws to keep pace with India's changes in the economic world. So laws have to be brought in to keep pace with the way society develops. One of the best things to look at are personal laws. Now you take religious and personal laws. You find that courts today are interfering even in religious matters. Why? Because society demands of them that there should be a change in the old customs, that customs that existed before have to change. We have to change with the times. Therefore, the laws which provided for different personal laws and was totally subservient to religion in the past are now looking at making a uniform civil code. That happens on that legal side. Then you find attitudinal changes. Society changes attitudinally. Now, when it does so, you have to have laws also which change the same way. Now, which is why you have the ever-growing format of fundamental rights. You have privacy now being made a fundamental right, because today's growth of man demands a right to privacy, and privacy is now seen as a basic human right. You see the laws which had banned homosexuality, which had made homosexuality an offense, those laws have been struck down by the courts because, again, they have to change with attitudinal changes of society. So all these will see that necessarily laws have to change and keep pace with societal growth or societal changes. And laws can never keep stagnant, and the dispensation of justice also changes with this. Which brings me to the last and most important point, which is what you raised about the number of pending cases and what is happening in this country. And that is because of the demographic changes in India. Our population has risen, but it's not just the population. It's a population which goes to court which has risen, which is why you have so many pending cases all over the country. And as you say, the courts today at the subordinate level, where it's actually inter-citizen disputes, which is what courts are really meant to sort out, those cases are forgotten. Why? Because the government of India is involved in 70% of litigation. The government of India sets up its own tribunals. And then if the tribunal's decision is against the government of India goes on appeals. If you curb the appeals filed by the government of India, I assure you, you will get rid of half the pending cases in India, and you will have more time to dispense justice between citizens, which is what must be done. So for an opening remark, this is what I would like to leave it at.
Very well said, Mr. Aryama Sundaram. Two things that I picked up from what you had to say. One, I thought you are in favor of the Universal Civil Code. Now, you were seen as one of those lawyers, one of those senior counsels who hadn't picked a side politically. Today, your averments on a uniform civil code, well, I don't know where that leaves you and how public perception is going to see you, because uniform civil code is among the topmost agenda items for the BJP. So have you really become a saffron senior counsel? That will be the next issue.
Let me answer you straight away. My political views and my neutrality in politics hasn't changed at all. The concept of a uniform civil code I was pointing out to you is because of the change in societal views. In society itself, if you know the number of Muslims, in fact, who appreciated the talaq judgment, you know, we have to look at it as these are areas where, if we are a unified society, the social norms demand a uniformity in social laws. And that is what I'm trying to say.
Good attempt at clarifying, but Mr. Aryama Sundaram, the headline is already out. Everything else that comes later is just pure damage control. But let me turn to Mr. Raian Karanjawala. Mr. Raian Karanjawala, it's not as if India has any dearth of laws. It's not even as if, we have to look at some of the evolving needs, because we have new laws coming up every now and then. But the real question is, are we able to dispense with justice for the common man, for the common company, for the common entity? That is the big question, and that is where legal reforms are required. As Mr. Aryama Sundaram said, the government selects people on tribunals, but it is the government which is involved in the maximum amount of litigation. So, Mr. Raian Karanjawala, what are your thoughts on legal reforms, the need of the hour?
You want my opening remark, or you want me to answer the question you asked?
Your opening remarks, and maybe we'll get to the questions, but so if you can include an answer to the question, who knows, a bonanza will come our way.
So, Navika, since this is an economic conclave, I thought I'd confine my opening remarks to the impact that judgments of the court sometimes have on the economy, sometimes in a detrimental way, and give my suggestion as to how I feel we can iron out the creases. I was just talking to Pallavi outside, and we were remembering our days when we both joined the bar, which was 40 odd years ago. And the distinction between the bar and the bench in the last 40 years has been enormous. The obvious way to note the distinction is to just pull out newspapers that are 40 years old, read them. And you could spend a month reading the newspaper without ever coming across any write-up about what happened in court. Today, you can't open a morning newspaper unless you see at least 4 or 5 stories as to what just transpired in the court yesterday. Some of these judgments of the Supreme Court, which are now all permeating, have also had huge economic impact. I'm going to just itemize 3 before I make my suggestion. The first judgment, which everyone is aware of, is, of course, the 2G case. Over there, spectrum had been allotted on a first-come, first-served basis. That was challenged. And ultimately, the challenge resulted in 2 things. First, this was somewhere in the year 2008. First, there was a criminal case in which several people went to jail. They succeeded, and then the matter is now in appeal. There was a civil case in which 122 telecom licenses were cancelled. This was partly because this particular case was judged even by the Time magazine as the second largest abuse of power case in the world. The first they had put as Watergate. 122 licenses were cancelled, 16 odd telecom companies were closed down. Several, the Controller and Auditor General said that the impact, the adverse impact of that particular policy on the government and on the exchequer was 1,76,000 crores. The licenses were set aside, telecom companies got closed down, and today the fallout of it partially is that the telecom companies owe almost 7 lakh crores to the banks. I'm not saying they won't be paid up, but that is the impact, 1. The second case, which is important, is the coal block allocation case. The coal block allocation case, 218 coal block licenses issued from 93 to 211 were cancelled because it was felt that they had been issued in an arbitrary and illegal way. The impact of that case alone was that they felt that the stressed NPAs on the banks itself was over 40,000 crores, over 90,000 crores, sorry, and about 24,000 megawatts of captive coal-based thermal capacity was under stress. The third case, of course, which I just mentioned before I make my point, was the Goa mining case. 88 iron ore mines, which were renewed in the year 2014 to 15, were suspended. And though in that case no corruption was found, what people said was that they were issued in undue haste. Now, from this it is evident that many cases come up before the court which have a huge economic impact. How do you deal with them? Personally, in my view, I think the time has come when the court must institutionalize an economic amicus curiae. An amicus curiae, as all of you know, is a friend of the court. When a court is dealing with a complex matter, which it feels requires more assistance than it is getting, the courts often appoint a legal amicus curiae, who then steps into the process, helps the court arrive at a proper decision. The time has now come when we think beyond the box and outside the box, and we decide to appoint institutionally, at least as far as the Supreme Court is concerned, an economist as an amicus curiae, or a panel of economists institutionalized as amicus curiae. So then what happens is, when the court is dealing with a particular matter, which it feels has a huge impact, they can call in the services of one of these economists, ask him to study the case, ask him to extrapolate as to what the impact of that particular judgment, if it goes this way or that way, will be, and circulate it to all the parties concerned, and keep the inputs of the economist into the mix when the court ultimately arrives at its decision. And the important thing to know is that this would also be in consonance with the court's powers under Article 142, which is to, at times, step in and do the complete justice of the case. So you may well have a situation where you hear what the economist has to say, you strike down what happened, but you mold the relief so that the adverse economic impact on the country is not too much. This institution could also play an important role when deciding which cases should be heard and with what priority. For example, I saw the other day, I was looking at it, I was studying for it, the Narmada Bachao case lay pending in the courts for almost 6 years before it was ultimately decided. A panel of this kind could well have suggested that this is not a case that should be allowed to pend, it should be heard immediately. Equally, yesterday we saw in the newspaper in Times of India that the Solicitor General has appealed to the court that Hindustan Zinc shares of the government have to be sold, so please expedite that case. These are also situations which the court must look at when it decides cases which have an economic impact. Not only which way to think when you decide them, but how quickly such cases must be decided. That's my opening thought.
Well, thank you, Ryan. Many questions that come to mind, but we'll hold the questions for a while before I turn to Mr. Sidharth Luthra. Mr. Sidharth Luthra, your recipe for legal reforms before we get into the pluses and minuses of some of the suggestions that have been made so far.
Well, I'll tell you, the last few years have seen some legal reform, both on the legislative side, the administrative side, and even in terms of creative interpretation, be it temple worship, Sabarimala, Aadhaar, the right to women to be enrolled in armed forces, or even the right to women to ancestral property. Having said that, I would say we need to consider reform at two planes, legislative and administrative reform, and judicially required or judicially mandated reforms. One thing that the change that has come about by the pandemic is that we've changed completely from the physical court mode, almost completely, to the virtual court mode. And today, this has brought about an era of efficiency, of efficacy. We were stumbling in the initial stages with hiccups. We used to do hearings. I've done a hearing on WhatsApp. But now things are a lot better and things have smoothed out. You've had constitution benches repeatedly hearing matters, and that is a great change. But having said that, while we've managed to avoid the spread of COVID within the court system by shifting to the VC courts, we have other issues which need to be dealt with, and that's a question. There were unused funds lying with the courts since the e-courts came in 2014. 13-14 is when the e-courts project came. 40% of the funds were used. Why didn't we use it all these while? And there needs to be a serious rethink as to bringing in technology to make the administration of the courts easier. The second point that I want to make is we have a severe shortage of human resources. And when I say shortage of human resources, today judges don't need to work from courts, they can work from their own homes. They can deliver justice through the VC system. 39% odd of the High Court judges' positions remain vacant. The Supreme Court, in a judgment a couple of years ago, said you must appoint district court, trial court judges on an annualized basis. It's not happening. The question is why. And that's an area of reform, because if you want to deliver justice, you have to make access to justice a reality. You can't have numbers which are unsurmountable before by judges, fledgling number of judges. Now the fact is, there is also reform needed in the way judges decide matters. One of the things we've learned is the value of liberty. Ryan talked about how matters are not decided, economic matters are not given priority. My biggest concern is, every time you defer a hearing on personal liberty, on detention, on bail, you're really keeping a person in custody. And on what basis? I can tell you my personal experience. In courts tend to indulge government too much. This is a chronic issue. Government, I've been a law officer myself, and I know we used to get a lot of indulgence in courts too today. Yesterday, I was before a high court, and I told the judge, I said, you know, this is an illegal detention. the state wants 2 weeks to go to the Supreme Court, you're really perpetuating illegality. And the answer I got was, we are not just courts of law, we are courts of equity, we have to balance issues. Can the right to liberty be balanced? That's a question judges need to ask themselves. Can it be balanced against societal or administrative considerations when the detention is absolutely illegal? The other area of concern is, and this is where I look at legislation and administrative reform, we have a flurry of regulations which come in. You know, there was a ruling on the cryptocurrencies. Now the government wants to ban cryptocurrencies. I don't know if you've seen the recent regulations on OTTs and intermediaries. You're really destroying the fabric of the Information Technology Act protections. There'll be nothing left for intermediaries. But the last thought I want to leave you all with is, we're in a changed world. Information technology itself has changed this world. And therefore, we need to go back to something that the English thought of about 100 years ago. Traditionally, legislation sets out the framework, the delegate, which is the government, can add the commas and full stops and fill the gaps, but do no more. In the Epidemic Diseases Act in the late 1800s, everything was left to the government to do. Legislation was broad. Today, in a world of technology, we have to change how we look at legislation. Legislation can never, ever keep pace with technology, and therefore we will have to have broad-based legislations with immense powers to the executive. But the check on those powers will have to come from the court system. The question is, are we up to it?
Thank you, Sidharth, but let's throw open this panel. And Raian, you came up with some very good suggestions. Yes, we've seen the economic fallout of some of the decisions of the courts. But I'm not coming from a legal position. I'm not even coming from a government or an investor position. I'm coming from an Aam Aadmi position. And from the Aam Aadmi point of view, what happened in the telecom licenses was, the general perception was that there had been bending of rules, there was crony capitalism, and therefore, the kind of distribution of licenses that had happened were not fair. Are you saying, if you have a panel of economists who were to advise the court, because there are large investments involved in this, the issue of justice, the issue of criminal crony capitalism should be set aside because there are investments which would be affected? How do you find a balance between these two?
No, not at all. Of course, if there's a wrongdoing, it has to be punished. There's no doubt on that. The question is, if you're confiscating the property from that person, could you have instead, in addition to, say, the criminal aspects of the case, imposed on them an additional burden, imposed on them and said, you can continue, but you must pay what you would have paid in an auction? They're all, see, I gave one example. There are many cases in which the economic mix into the arguments is beneficial. The courts may just look at it and decide. All we are saying is that the courts have a more informed position by which to deal with the case. They're not just dealing with the economic aspect in the dark, because lawyers themselves are not that well equipped to illustrate the economic fallout of a case. You may still completely reject the economic amicus curiae argument and go ahead with what you were originally intending to do. There's no doubt about it. And certainly 2G was an exceptional case. As I said, it had been pointed out as one of the largest abuses of power in the known democratic world. So, I mean, probably the decision would have been the same, or they may have worked out something. One isn't able to understand. But it's always better in cases which are complex to give them, come to judgment with a fully informed viewpoint.
Can anybody deny that there will be the requirement of subject matter experts? For example, just a couple of days ago, there was an issue about, which target group should be vaccinated first or second, and that matter was before the Supreme Court. Aryama Sundaram, do you think the time has come for courts, as Raian suggests, to have subject matter experts to be amicus curiae, or possibly in the American style, have a jury system where there are different experts who come in and advise the court?
Look, from a practical point of view, as a person who appears before these courts every day, let me tell you that what the courts do is, when it's a matter which involves an expert panel which is required to decide it, very rarely differ with the opinion and going on the basis that when an expert panel has decided this, we should not interfere lightly with it. So you'll find that very, very rarely does the court ever twist or change anything that an expert panel has said. What the court looks for is there any malefides? Is there anything suspect in the way everything was done? But if there was an expert panel appointed and the expert panel has said something, the courts always go by it. So the question of the courts appointing an amicus curiae on these economic matters, I'm not fully in agreement with Raian here. I feel that courts do subject themselves to the views of any such expert panel, and only interfere when there has been a violation of law in the procedure in making a decision, or there is something so arbitrary and wrong in the decision that they have to take a relook. And in many cases you find where there are no expert panels which decide, but where the court feels that they require something to be looked into, the court then appoints a special body to look into these matters and give their reports to the court, and then goes by that report. So I feel that to a great extent is noticed and appreciated by the courts, even today.
Let me raise the other question. You spoke about the fact that e-courts should be there, virtual hearings in most high courts, and the Supreme Court has been the new learning that has come in from this 1 year of fighting with the pandemic. Let me ask you this at a very practical, cutting-edge level. We're talking about working out of a city like Delhi. What about Mofussil towns? What about district courts in smaller places? Can they afford to have virtual courts running for as long as they have run right now? Are you saying there is no pendency of cases in the Supreme Court from petitioners who are from small towns? Are you saying that there are enough lawyers who will be heard in the virtual hearings that happen in the Supreme Court or in the high courts? Are we only looking at one side of the coin and not taking a holistic picture, given the fact that we are a country of diverse populations, diverse economic strata of society, and diverse kinds of cases coming to courts?
Let's divide it into three categories: the original courts, the constitutional courts, the high courts, and the Supreme Court. Let me put it to you in the context of a litigant, let's say in Tamil Nadu or in Agartala or in Surat. Today, the cost to the client has diminished. He or she can access a hearing in the Supreme Court. He does not have to travel. His team of lawyers does not have to travel. The cost of litigation for that litigant has come out substantially. And he or she can watch every step and see, did the lawyer perform or not? So there's somebody watching over you, number one. In the high courts, it is really a matter of how the courts have chosen to function. I was in a high court yesterday where the court does not sit beyond lunch. I mean, how can you justify that 1 year into the pandemic? You cannot. That's an individual decision, which is unfortunate. Every hearing, you're only unmuted if you're speaking or if you're in the matter, but there was a complete access. It was like a real court. Anybody could watch every single proceeding. Madhya Pradesh, Uttar Pradesh, they had these systems. The trial courts, we've had a problem, and I completely agree with you. The trial court infrastructure has not been geared up, and that's a tragedy. But then who do we have to blame but ourselves? What were we doing with the money that was lying in the e-courts project for so many years? And therefore, today, Navika, we have to change our system in two ways. The Delhi High Court illustratively has come out with rules for providing for remote locations where evidence can be recorded and proceedings can go on. The point is, when the resources have been allocated, why is it that we have not used the COVID months to bring in that infrastructure? It's a populist attempt to say that we should have, and I must be very candid, that we must have physical courts. but at the risk of people's lives. Today, the pandemic is coming back. Unfortunately, we seem to be stuck in a second wave. Having said that, in the district courts and smaller towns, where access to justice through the VCS electronic system is limited, you must also remember that it is easier for a person to afford a mobile phone and attend a hearing than to travel from Ghaziabad to Allahabad, which is a 9-hour journey by train. You and I can travel by air, they can't.
Fair point, but there are some numbers that I want to present before this August panel. There are 60,000 cases pending in the Supreme Court. There are about 44 lakh cases pending in various high courts, and there are 3.1 crore cases pending in several subordinate courts. At the same time, let me tell you, there are about 419 judges positions that are vacant in various high courts in India, and over 4,000 such vacancies in district courts. And we've had a situation where there has been a Supreme Court judgment which says that we must have a memorandum of procedure which lays down the procedure for appointment of judges to high courts and the Supreme Court. This judgment came in 2015, but not 1 inch has moved in this decision. How are we ever going to have any reforms in the judicial system if these are the numbers?
So the answer is a mismatch of numbers. Too many cases, as you rightly pointed out, too few people to do it. And frankly, to some extent, the blame has to be shared between the judges and the government. Because these are the two appointing authorities. The judges decide, the government permits, and then the judge gets appointed. There is really no reason why there should be a void in any court at all. You know when a judge is going to retire. You just get down to appointing people on that judge's retirement immediately. You have the talent before you. You know who the people practicing before your courts are. You come to a decision and you appoint. I mean, frankly, it is something in which I feel that both the judges and the government has lacked leadership. And it's something that I do hope that the next Chief Justice of the Supreme Court puts on priority, because this is the fundamental problem of India's litigation system. Too many cases, too few judges, too many litigants waiting. An empty courtroom is not just an empty courtroom. It is a long queue of people waiting for their cases to be heard, which will not be heard will be heard in their lifetime, but not be heard in the immediate future. And ultimately, you will reach a stage where, even when he does get his judgment, the litigant will go home a distraught person. He may have succeeded, but too many years after he should have.
That's right. Several cases pending over the last 3 decades. What kind of a position would you be in if you had some matter pending in courts and had to wait for 30 years to get justice? Think about it, ladies and gentlemen. And our guest later tonight is going to be the Union Law Minister, and we're going to not only give him the suggestions that have come out from this panel, but we're going to really ask him some tough questions.
If I may come in, Navika, just for a second. One of the things they can take advantage of is the virtual court. Because a virtual court requires far less infrastructure. If you appoint a whole series of judges who will hear cases parallel virtually, then in one building you can house so many more judges than you would require whole courtrooms to house, because everybody just handles the case virtually. This is a time when you must take advantage of whatever technology is available to try and improve the situation. This has to be the silver lining in the COVID cloud.
Absolutely, and with the Law Minister also being the Telecom and IT Minister, I think his work is cut out for him. Thank you very much, Raian Karanjawala, Aryama Sundaram, and Sidharth Luthra for joining me on this panel on legal reforms. Thank you.